Yes, since I'm part of the organizing committee, I was polite enough to put myself last, so that no one else had to keep you bored before going home for dinners. Well, I will be talking about the relationship between Dominican Republic and the inter-American system of human rights, in particular the domestic reaction to the Jonin Baucicault sentence. It will definitely link up to Samuel Martinez and also to Ingvild's presentation, I hope. And there will be some repetition, but I'll skip through some of the laws that we've already seen. So I just need my notes. There we are. So the principal question that intrigued me with studying this topic for the Dominican Republic was what explained backlashes to international human rights regimes. And a backlash is understood as a domestic or local reaction that diminishes or weakens the position of an international human rights regime locally, and also or generate a negative reaction against the population that the international human rights regime is supposed to protect through a sentence or through treaties. And of course, the Dominican Republic and the reactions that we've seen, and Cristobal and Bridges have also been talking about earlier, towards the Jonin Baucicault sentence is definitely a backlash. I would say it's a two-pronged backlash. One is it affects the rights of the affected population, and the other is it has weakened the status of the inter-American system of human rights. So there are many theories on compliance, in other words, the degree to which a state complies with international human rights court sentences. There is very little written on backlashes. So I thought this was an interesting topic. So I tried to focus on three things. One is the issue. The issue at stake here was perceived, at least by elite, as a clear attack on national sovereignty. It is touched upon an issue that is very close to what defines the nation state, namely to define who has the right to be a member of this nation, right? And that helped, in one way, mobilization against the international human rights regime, but also kind of weakened mobilization in favor of the international human rights regime because of the issue at stake. And it's touched a bit upon what Ingvild was talking about. I'll also discuss how it was possible for a small state close to the bigger neighbor of the United States, and also other neighbors that tried to fight for the human rights situation of the migrant population in the Dominican Republic. And one of the issues is that several of the backlashes came through autonomous institutions, independent of the government. Formally, at least, that ties the hand of the government. It facilitated the backlash, and it made it easier to uphold, partly because international pressure and local pressures is rendered less effective. And looking through several documents, I think the goal for the deciding elites in the Dominican Republic is a re-domestication of the citizenship regime, in a sense. And we'll look through that as I go along. Now, the strategic litigation all became possible in the late 90s because the Dominican Republic became a member or signed up for accepting the court's jurisdiction in 1999 through a decree made by President Leonel Fernandez. So of course the InterAmerican Court has been in existence since '79. It's a part of the international system of human rights, part of the OAS, and it works with the Commission. And the rulings are of course binding by member states and become part of international law. So international human rights regimes or courts face the challenge of advancing human rights in states that may resist supranational decisions and that suffer from large-scale endemic human rights violation. And this is, of course, the situation in several countries in Latin America, not only the Dominican Republic. And the court, in a sense, has a low to medium success in achieving compliance of the sentences. And as we will see, the Jonin Baucicault case actually fits the standard of compliance, but it also has attached a backlash that is not that normal. This points a bit to the strategic aviation that started. Samuel Martinez mentioned the Berkeley lawyers. Of course, the only way that they could go through international litigation is that the Dominican Republic, as I mentioned, became a member or accepted the court's jurisdiction in 1999. That made that path open as a strategy for fighting for migrant rights in the Dominican Republic. Now, one of the theories of what affects compliance is the degree of the regime's democracy, standards of democracy. And if you look at some of the changes, aside from the right situation of the migrants we're discussing today, is there are positive changes in the constitution. The American Convention went from a legal status to a constitutional status in the 2010 constitutions. There were specification of basic human rights, and there was a new constitutional court that is supposed to uphold and make sure that Congress stays within the constitutional parameters. So there are, formally at least, positive signs that things are going on that may improve the respect for international human rights. But then comes, of course, the Jonin Baucicault case, and it makes a specific reaction with respect to the citizenship regime. I will not go through the details here. You've heard this partly before, but the state lost. And what was important is that it clearly specifies the jus soli clause and restricts the concept of transit, which Cristobal talked about earlier. The sentence was partially complied with. And it's the default level of compliance. Reparations are generally paid, but in terms of the broader issues that could affect the rest of the migrant population, this is of course not complied with, and that's not very normal in Latin America at all. As I mentioned, two-pronged backlash, the rights of the affected population, that's been all the laws and sentences that other people has mentioned, but also the status and standing. I will just quickly go through these. We've seen these. What they do is two things, basically. They widen the laws, and the constitutional reform widen the definition of transit. And the Junta Central Electoral and the Constitutional Tribunal gives these changes retroactive effect. Those are the two issues at stake, and of course they affect negatively the population we're discussing. But also we see a weakening of the inter-American system of human rights through several acts. Congress passed in 2005 a clear rejection of the Jonin Baucicault sentence. There have been attempts to pass resolution against the resolution 1207 of the Junta Central Electoral, never won a majority. And it also questions the state's adherence to the court. This is supported by a Supreme Court decision that's already been mentioned from 2005, which questions the right of the president to decree adherence to the court. There are other sentences in 2009 that questions the supremacy of the court, the convention, and the sentences in the Dominican constitutional system. And there are other issues. For instance, in the Constitutional Court sentence TC 16813, neither the convention nor the Jonin Baucicault sentence form part of the legal basis of the sentence. So it is a sentence that was supposed to have a general effect is totally ignored. And there's also been later sentences after 16813 that just basically ignores completely the Inter-American Court of Human Rights and the Jonin Baucicault sentence and just refers to the 16813. So the jurisprudence that was supposed to be set by the Jonin Baucicault sentence is completely ignored if you want to read the sentences. It's part also of the redomestication of the citizenship regime. So there is a clear weakening of the status of the inter-American system of human rights. The reasons are the issue, I would say. It creates a rally around the flag effect, and this points directly to Ingvild's nice schematics. It kind of weakens the effect also of international pressures because it puts local NGOs, local actors that are in favor of the human rights of the migrant population in group with international agents, perceived as attack on national sovereignty. So it helps mobilize against human rights, but it also makes it difficult to mobilize for human rights because local agents are often supported by international agents. And of course it doesn't help that the sentence come from outside either, because this is becomes an issue about defending the nation, about the right to define who and who is not a Dominican. And we can see the mobilization because this is not something new. In 2010, if one reads the debates in the National Assembly discussing the constitutional reforms, you would see that one of the extreme rightists, Pellegrin Castillo, is discussing, well, the Constitutional Tribunal is coming, and our opponents will use this to debunk the migration law of 2004 and La Junta Central Electoral, La Resolución 1207. And you can see that you won't be able to read these names, and that's okay, but these are clippings from the Supreme Court sentences in 2005. Some names are underlined. These are all names that defended the migration law and or sent to the Supreme Court an act of inconstitutionality of an agreement between the Commission and the Dominican state. And these are the names, and this is back in 2005. So Pellegrin Castillo was already discussing in 2010 that we have to be aware that the Constitutional Tribunal could be used to make unconstitutional the migration of 2004. I put this up. Of course, we know Pellegrin and Vinicio Castillo, FMP, but also active sponsors of or defenders of the migration law 2004. Victor Gomez Berges, who's now a tribunal, a member of the Constitutional Tribunal. Jotin Curi, hijo, also a member of the Constitutional Tribunal. Julio Cesar Castaño, also now a member of the Supreme Court. So they mobilized against international human rights through Supreme Court sentences back in 2005. And of course, after the constitutional reform in 2010, there are elections for both the Constitutional Tribunal, there are elections for the Junta Central Electoral, there are elections for the Supreme Court. And these members get elected. So one thing is for the civil society to mobilize and increase the pressure on governments, but there is also clear mobilization against international human rights regimes, but they do it within the institutions. And one effect of the strategic litigation is judicialization internationally, but it's also becoming a judicial issue nationally. And whereas the promoters of human rights win internationally, they tend to lose nationally because the mobilization against human rights has been more effective in the institutions than for the other side. And the other effect of the institutional autonomy is that it's harder to lobby for civil society and others. Autonomous institutions like the Junta Central Electoral, who won't even be audited economically by other institutions. It's really jealous of its independence. It's harder to lobby the Constitutional Tribunal. Public pressure is potentially less effective because these are not a person that has to be held to account, not at least by popular pressure. So institutional autonomy, as long as they're not on your side, works negatively in terms of the promotion of international human rights, even though it is supposed to be a positive sign of democratization. It's also interesting to see that the retroactive clauses that created the most international reaction has occurred in La Junta Central Electoral and the Constitutional Tribunal, not in Congress. One might criticize the migration law for many reasons, but the retroactive clauses came in these autonomous institutions, not in Congress. Another thing to bear in mind in terms of these autonomous institutions is that when one discusses the level of compliance, one thinks, at least a political scientist would think in terms of cost and benefits. You have to incur costs on the government so that they will comply. And of course the International Court thinks of the state only. It only sees the state, it doesn't see the institutions below. So the costs are not evenly distributed among institutions, in a sense. The government, the Dominican government, felt the heat after TC 16813 more, I guess, than the Constitutional Tribunal. And I also guess earlier, after the resolution in the junta, they felt the heat, but not necessarily the agents that are able to change the status quo for better terms. So the costs are not equally distributed among institutions. And of course we have the argument that has also been claimed by the Medina government after the sentence in the Constitutional Tribunal. These are autonomous institutions. If you follow democratic theory, they should be. So formally they tie the government's hand. Of course, Medina is, or the government is stuck between respecting international rights or overriding autonomous institutions in a sense. We may like or dislike that argument, of course, and we may of course also question the level of autonomy, because after 2010 the level of autonomy of these institutions have decreased somewhat. But either way, the government here loses, because you have to override the Constitutional Tribunal as independent, and that is anti-democratic, at least would be perceived as that locally. So that also creates some problems. I just put up the photo here of the two institutions. Incidentally, La Junta Central Electoral and Tribunal Constitucional are side by side by Plaza de Bandera. Rumors are that the junta lobbied hard to get the tribunal to pass the 16813 sentence, and succeeded in that since it, yeah. So the backlash has also entailed what I would define as a re-domestication of the citizen regime. The redefinition on national terms of what had been defined internationally through the Jonin Baucicault sentence. Of course, that sentence just tells the state to accept what the Constitution said, but we know that practice was different. So if you read the laws and sentences that have been cited by everyone here, it would almost everyone would say that the citizen regime is an inalienable right sovereign to the national state, nation state. It will say that the International Court went beyond their faculties. They would basically also ignore international rulings and treaties, at least the ones that are supposed to be more relevant, the Jonin Baucicault sentence. And interestingly enough, the law 16914, the naturalization law, is totally void of any mention of international law. It's not mentioned there with one word. At least former sentences do mention it. The Constitutional Tribunal sentence debunks the InterAmerican Court, but the 16914 law has no mention of international law. And it gives some nice words to the Constitutional Tribunal, calling it the interprete ultimo de la Constitución. And in the debates following the law, it was emphasized that it was written by local, domestic, and national legal experts. This was a local and national issue. And I see I have only 1 minute left. So I see that this backlash as an attempt to re-domesticate the citizen regime, to regain the right to define who has the right to be a Dominican national and who is to consider to be in transit. And I think, if I want to predict the future, that we've come full circles in terms of all of these laws and sentences now. I guess we'll see less of it. I think people are, elites that are in control of these are quite content with the new legal situation. But looking beyond the Dominican Republic, these kind of backlashes that we've seen in the Dominican Republic, we've seen that in Venezuela a couple of years back, some years back in Peru, attempts to reform the Commission by Ecuador, they may become a threat to the Inter-American system of human rights. It's not only the Dominican Republic that has questioned the supremacy of the Inter-American system of human rights. So if these become more common, I think they may become a threat to this international regime. Thank you.